Hello, my name is Joshua Getzler, and I'm here today to tell you about a brand new course for the BCL MJAW called Modern Legal History. Our course will examine the development of English law and common law tradition from the late 17th century till shortly after the Second World War, the 1950s. We will divide our study up into three parts: the long 18th century, from the Glorious Revolution of 1688 to the reign of Queen Victoria, then the Victorian period from the 1830s to 1900, and then the 20th century from the Edwardian period through the World Wars to the post-war period and the foundation of the welfare state and modern political democracy. We won't just be studying England or Britain, but the wider common law world, including imperial and international dimensions, developments in the dominions, and in the entire empire. We'll be curious to look at native title issues, the British Empire in India, and lawmaking in non-settler societies, colonial societies. We'll be looking at North America, British North America, the United States of America, and we will be also looking at civilian traditions, especially France and Germany, as they impact on the English family of law, but also the wider world of civilian law, which encompasses South America and the Far East. Students with strengths in either common law or civilian legal cultures are both welcome. Those students who know no common law at this point will probably want to do a little bit of reading before they start the course to get up to speed on how common lawyers think. We will be looking a lot at doctrinal internal legal reasoning, but we will not be stopping there. We'll be looking at the interplay of internal legal cultures and external influences in politics, economics, culture, religion, demography. Everything is open. We will be offering a flexible assessment. Basically, we'll be asking you to choose three major topics from our year and developing quite detailed and thoughtful knowledge about those topics. At the same time, we'd like to give you an overview of the entire development. Our guiding philosophy is that historical consciousness of the law will give lawyers today intellectual freedom to choose well in the kind of law that they make and apply. Legal history can give us a creative awareness of our sources, of the potentials within the law, and going beyond the law itself, it can help us understand the social world using law as a measuring device, as a metric. This mixture of internal legalism and external political, economic, social history puts us squarely in a great tradition, practiced by such scholars as Maine, Maitland, Pollock, Salmond, Holdsworth, Milson, Simpson, Atiyah, Horowitz, Baker, Brand, and Ibbotson. That's a great roll call of names of famous legal historians, and of those 12, 8 taught in Oxford. So this is still a very strong Oxford nexus. We have a great team of lecturers and tutors ready to teach the course, all scholars in their fields, covering contract, crime, tort, commercial law, companies, trusts, and public law. And we see this course as a wonderful opportunity to test our scholarship and to advance the frontiers, talking to the brilliant students who come to Oxford for the graduate courses. The main themes we cover are, in the first part of the course, the institutions of the law, business organization, the law of contract, land law, trust law, tort law, public law. Then in the second part, we move to the law of persons, a neglected area of the law, criminal law and justice, intellectual and comparative dimensions, imperial and colonial dimensions of the law, and interactions of European law. The idea that we have a native English law that was cultivated in this offshore island nation state and then successfully exported to the colonies and dominions of the empire will be held up to critical scrutiny, particularly important in these times of rapid political change. Our teaching materials will comprise primary sources that we are already familiar with, traditional case law and statute, but we will also look at professional journals, treatise literatures, pamphlets, judicial and practitioner handbooks and notes, statistical analysis, parliamentary and press debates, official reports, polemical literatures, any historical source that can help cast light on the development of the law. Let me give you an example. One of the most famous cases of the last 100 years is the snail in the bottle case, Donahue and Stevenson. And recently, historians have demonstrated that the 1930s judgments in tort law, creating our modern tort law, came hard on the heels of a very significant change in the way in which courts were organized. That is, the jury, outside criminal law, was practically eliminated from civil trials. So, knowing that and looking at the statistical decline of the civil jury can help us reframe what it meant to set up a large test, a moral causal test for responsibility in tort in a jury-free common law system. The first 6 topics in Part A will be taught in weekly seminars across Michaelmas and Hilary term, and we will be taking more than one seminar to cover each topic to go in depth. And we will be offering, in those 2 important Part A terms, 4 tutorials to every student, 2 in each term. But the main vehicle of teaching will be the weekly seminar, with occasional lectures where one of the teachers wishes to expound in detail a particular pocket of law. The Part B topics are more varied, and we will discuss with the class which particular topics they wish to focus on. And that will be taught in the Trinity term. Students with no knowledge of the common law will be encouraged to do a certain amount of pre-reading before the course commences. In fact, it would be probably be a good thing for all students to do a little bit of reading before we begin. We welcome you all to Oxford, and I hope that many of you choose to do modern legal history. Thank you very much.